You ever stopped in the middle of a scroll and wondered whether the rules you live by could flip overnight? Imagine owning what every gun shop clerk calls a common legal rifle, and waking up to find the law treats it like contraband because you crossed a line on a map. That's the exact fear that's been pulsing through millions of gun owners for years. And now something enormous just happened in Philadelphia that could change everything. 3 weeks ago, the Third Circuit did something rare and loud. It didn't wait for a half-baked panel opinion to land and then react. Instead, the court pulled the emergency brake and took the whole New Jersey AR-15 fight onto the full bench, sua sponte. In plain language, judges stopped a potential opinion before it could become law, and that single procedural move instantly raised the stakes from a local controversy to a regional and probably national constitutional moment. Why is that so dramatic? Because the AR-15 family of rifles isn't niche gear used by a tiny subculture. It's the single most common modern sporting rifle in civilian hands, with conservative estimates putting numbers well into the tens of millions. People use these rifles for hunting, competition, training, and home defense. When the Supreme Court told us in District of Columbia v. Heller that weapons in common use for lawful purposes deserve Second Amendment protection, they were writing with that reality in mind. Later decisions asked lower courts to test modern gun laws against historical tradition, not convenience. So when a 3-judge panel seemed poised to uphold sweeping New Jersey restrictions that treat AR-15s and standard capacity magazines as outside that common use protection, the full Third Circuit hit pause. That pause isn't a technicality, it's a signal. We're not going to let a panel quietly ignore Supreme Court precedent and reshape the rights of millions without a full, serious review. Here's the procedural picture worth understanding. Most appeals start with 3-judge panels. If you lose, you can ask the full court for rehearing en banc, and only sometimes does the court agree. But the Third Circuit didn't wait for a losing party to beg for rehearing. The court acted on its own authority before any panel opinion was final. That's rare. Courts use sua sponte en banc orders when a draft opinion threatens to collide with controlling Supreme Court precedent or would create chaos across jurisdictions. Why? Because a panel ruling that undermines Heller or misapplies the tests from recent Supreme Court cases wouldn't just bind New Jersey, it would become persuasive precedent for Delaware and Pennsylvania too, and could be copied by restrictive states across the country trying to legalize bans by stealth. By stepping in early, the Third Circuit effectively said, "Not on our watch. We will square this with Supreme Court doctrine ourselves." Now let's talk stakes. The math inside the Third Circuit is razor thin, and every single judge's history matters. By most counts, there are 7 judges who lean toward a textualist, originalist view of the Constitution, and 6 who have demonstrated broader tolerance for gun regulations, with 1 senior judge whose votes have sometimes surprised observers. That means a single vote, 1 swing judge, can determine the outcome for millions. Chief Judge Thomas Hardiman is the name everyone is watching. His opinions show a deep respect for constitutional text and for the Supreme Court's insistence that modern gun laws be measured against historical tradition. If he sets the tone and insists Heller and its progeny govern the analysis, the rest of the bench will have to grapple with that framework. On the other hand, if a majority of the full court embraces a different interpretive path, the result could be the opposite. And there's an added variable in play: judicial appointments. The White House has nominated a nominee to fill a vacancy who is widely understood as an originalist. If that nomination clears the Senate before oral argument, it could shift the arithmetic from a precarious 7-6 to a more comfortable 8-6 for those favoring a textualist approach, a change that could turn anxiety into momentum for gun owners. This motion for en banc review matters for another reason. A reversal in the Third Circuit would create a direct conflict with decisions in other circuits. The Seventh Circuit, for example, has upheld certain restrictive state laws in ways critics argue underplay Heller's common use reasoning. The Ninth Circuit has sustained California's aggressive regulations, and the Second Circuit has backed New York's heavy-handed approach. If the Third Circuit moves the other way and rules that AR-style rifles and standard capacity magazines are constitutionally protected, you would have federal courts in different regions saying opposite things about the same firearms and the same magazines. In the legal world, that's called a circuit split, and a circuit split is often the fastest route to the Supreme Court. The court treats conflicting federal appellate decisions as a signal. It's time to step in and resolve the constitutional confusion. Think for a moment about the practical implications. Right now, a law-abiding citizen in Pennsylvania might be perfectly legal at home, but risk becoming a felon after a weekend trip into New Jersey. Businesses and gun ranges are left wondering what sells in one state but might be illegal in the next. Police departments, prosecutors, and defense attorneys are all juggling the uncertainty. If the Third Circuit ultimately rules that AR-15s are protected under the Second Amendment, that would not only blow a hole in New Jersey's bans, it would reverberate across states with copycat laws and give lawyers a powerful new precedent to cite in challenges. If the court rules the other way, it won't just be New Jersey that benefits. Restrictive legislatures across the region would have a legally sanctioned blueprint to expand bans and criminalize ordinary ownership. That's why the sua sponte en banc order is more than procedural theater. It's a fulcrum moment that could determine whether the Second Amendment is recognized as a living protection for weapons in common use, or whether courts are allowed to carve exceptions until the right becomes meaningless. Let's be clear, this isn't a guaranteed win for gun rights advocates. En banc review simply raises the contest from a three-judge skirmish to the full bench, where precedent and doctrine must be confronted head-on. The Third Circuit's recent composition has shifted toward judges who respect historical and textual analysis, and that gives advocates reason to be cautiously optimistic. But courts do complicated thing. They look at history, but they also examine legislative intent, public safety arguments, and the specific features of banned weapons. The real battleground will be how the judges apply the Supreme Court's guidance. Do they treat modern firearms as the court instructed in Heller and Bruin, as protected if widespread and commonly used for lawful purposes? Or do they instead allow judges to weigh competing policy interests and public safety arguments more heavily? The en banc hearing forces that exact question into the open. There is also an often understated political dynamic playing out in the background. The Senate confirmation calendar and Washington's appointments machinery are part of the story. Judicial nominations used to feel like distant, abstract fights that only Washington insiders tracked closely. Not anymore. In this case, a single confirmation could meaningfully reshape the way 12 judges see a constitutional issue and tilt outcomes definitively. That's why activists on both sides of the debate are monitoring Senate hearings, filing briefs, and pouring resources into amicus campaigns to educate judges on history, ballistics, and empirical data about usage and safety. If you thought court fights were only about dry legal theory, this moment proves otherwise. A judicial nomination, testifying senators, and even the timing of a hearing can directly influence whether millions retain a firearm widely considered part of American life, and the timing is striking. This summer's filings and the court's rapid sua sponte action create a schedule that could land this case before the Third Circuit en banc in October. Autumn arguments followed by months of intense legal parsing. If the decision produces a circuit split, the path to the Supreme Court speeds up. The court has already signaled interest in modern weapons issues. Several justices have publicly acknowledged the importance of a clear test for modern arms. When courts at different levels are saying diametrically opposed things about the same weapons, the Supreme Court is likely to accept review. That means the New Jersey case, which started as a state-level battle over local firearms policy, could end up as the vehicle the High Court uses to define modern Second Amendment doctrine for the entire nation. Now imagine the ripple effects if the Supreme Court takes up the case. A favorable ruling recognizing AR-15s and standard magazines as protected would not only block New Jersey's current prohibitions, but it would also force states and localities to retool legislation that criminalizes common ownership. Permitting schemes, magazine limits, and broad bans would be subject to renewed scrutiny. On the flip side, a decision allowing broad prohibitions to stand would validate restrictive approaches elsewhere and give state legislatures a legal green light to push for more aggressive limits. Either outcome will reshape policy, politics, and lives for years to come. For everyday gun owners, the practical takeaway is simple. What happens in Philadelphia will not stay in Philadelphia. If you own an AR platform rifle or standard capacity magazines, you should pay attention. If you travel across state lines for work, hunting, or family, the legal status of what you own could depend on a vote by 12 judges months from now. For lawyers and activists, the case is a clarion call to marshal historical research, evidence of common use, and practical demonstrations of how these weapons are used lawfully in millions of households. For politicians and citizens, this moment should inspire engagement, public comment, calls to elected officials, and participation in the civic process. The right to keep and bear arms doesn't defend itself. It depends on people who care enough to show up and make the argument. I'll be blunt. This is one of those rare, once-in-a-generation procedural moves that actually matters. The Third Circuit's decision to take the case en banc on its own motion isn't courtroom theater. It's the judiciary recognizing that the potential consequences extend far beyond one state's borders. It's a recognition that when a panel opinion could contradict Supreme Court precedent or produce chaos across a multi-state region, the full bench needs to weigh in. That's a heavy responsibility and a rare opportunity for clarity. It gives the Third Circuit the chance to align lower court doctrine with the Supreme Court's instructions, to either reinforce Heller and Bruin in a way that protects common-use arms, or to lay down a new, controversial template that could invite a unified Supreme Court response. So where do we go from here? Watch the calendar. October is the month that everyone has circled. Expect briefs, amici filings, testimony, and intense media coverage. Expect the confirmation calendars in Washington to become part of the story in ways they rarely have before. Expect advocates on both sides to double down, not because they enjoy the fight, but because the outcome will really matter. It will determine whether a rifle your neighbor owns is treated like household property or like a weapon of war. The stakes are constitutional, personal, and immediate. One final question I want to leave you with, because the courts can only do so much. How much will you do? Courts are arenas, but democracy is where policy lives. If you care about the future of common-use firearms, what are you going to do today to make your voice heard? Call your representatives, join local meetings, educate yourself about the legal filings, and tell your story. The Second Amendment doesn't guard itself. It takes citizens to do that work. If this analysis opened your eyes, hit subscribe, drop a comment below with your thoughts, and share this video with someone who needs to see what's actually happening in the Third Circuit. Stay sharp, stay informed, and stay involved, because right now, history is moving fast, and your attention matters.